I saw the Stiffen order, the Hunter Brown discovery deadline, so we've got enough for me to do on that. Yes, sir. And what's the issue regarding the Silver Springs insurance policy?
I think they give it to us.
Oh, you've got it.
We've got it.
And then the terrible Herbst digital forensic exam. What's the issue on that, Teddy?
There's a couple of things. We've been trying to get access to Terrible Herbst. Perhaps their server, I don't know if they have cloud-based, I don't know if they're server-based. But I've had a conversation with Valerie Rojas, but it's my understanding that they're getting new counsel. So that's been pushed back and forth. We just want to get a date.
We look for sales.
We found during the last Watson trial, right during trial, we found documents that had not been produced previously related to real water. They found them. And then we went through some issues, of course. And so now we want to see and take a look several years back and see if we can find everything. Hopefully, based on what we know.
What's the scope? What are you looking for? Inventory, purchases, real water
We're
sales.
talking
More even back large at first.
Oh, okay.
And these video commercials. Well, what really concerned us is the IT guy testified that he did not look for archive deleted files. So he didn't look for him. We think get our guy going there with their supervision. But
What attorney are you working with for
Valerie Rojas is who I've been dealing with, but she told me that they're getting ready to release that file to another firm. The other lawyer, who's Jim Kavanaugh, said that he's not, he hasn't gotten out of real water for Tennessee yet, so he can't take the file until that's done. So this last month we've been waiting. So now she's been cooperative, but we did find out there were many emails with Anthony Randolph of Real Water related to pump and pour discounts, the use of video marketing information, all of this stuff. And based upon what we found, they were partners in terms of selling real water. So we know they've been doing it almost from the inception of real water. We want to go back, arguably until 2010 forward, and go through these documents. Hopefully their files will figure this out.
I saw several substitutions in the Gallagher case.
Yeah,
right.
they seem to be
I
happy.
mean, we've been trying to get this thing rolling for 2 or 3 weeks, and like Teddy said, they've been cooperative. They said they'll work it out with us, and they seem to have some kind of which attorney's going to do what, when. It's been dragging on now for 2 or 3 years.
Yeah, we just want, and I will tell you, Ms. Ross said that she's not necessarily opposed to us doing it, but we've had this problem with the changing of the guard, so we should get that scheduled.
Is there anyone in the Zoom Terrible Herbst?
Yes, this is Jan Tomasik appearing for Terrible Herbst. I'm covering for Valerie Rojas. She had a last-minute scheduling conflict, so she wasn't able to attend, and we apologize. Now, just like Mr. Parker said, she's been cooperative. We will get in touch with Mr. Parker, Valerie and I will, and maybe this is something that we can discuss at the next agenda. I didn't know that it was on today's agenda to discuss this. All of the issues that have been raised are on the transcript if we need to bring them to you for review. But like Mr. Parker also said, there's a substitution of counsel. And so we just want to make sure that it makes sense for all parties, whether we start this now or later on.
Well, I don't want to delay this to my next hearing. I mean, if some of this evidence was introduced at the last trial, there shouldn't be much issue. Why don't you, either you or someone, whoever's going to be assigned, why don't you get a hold of Mr. Parker and arrange for a meeting within the next week to 10 days? And then whoever is involved in that meeting, let me know if there's a dispute afterward, and we'll get it into a hearing.
Sounds good. Thank you.
Thank you, Jan.
And then Now, the IMEs that I understand are at issue are Sherry Rasmussen, Pamela Brown, Hunter Brown, Carla Marino, and James Delmar. They have asked for IMEs of those plaintiffs.
Well, they've asked for psychological claims. They're pretty
That's
expensive.
right. It's neuropsychological.
They want to interview them and have question 3 hours. And then depending on what the responses are to the questions, they want to do certain testing.
I thought he wanted 2 days.
Yeah, one day to do the examination, the next to do the testing. We think that what they ought to do is they haven't even deposed these five. They haven't filed a motion, so we think what they ought to do is they ought to depose the 5 plaintiffs, see if they really think the claims are serious, warrant this kind of thing. Have a meeting, confirm with us, and if we can agree something, great. If we can't, then they should file it Rule 45. We think this is just putting, the cart before the horse, and especially when they haven't even deposed.
Well, I have to tell you, in the standard old-fashioned personal injury case, I did the IMEs before the depots, but I can understand on psychological, that's a little different than somebody saying my back hurts.
Right.
So,
And the depots are all set. I had that as the first item. These depots will be done in the next 4 weeks.
well, but if the depositions are being taken before this issue of IMEs worked out, that's fine, but I'm inclined to let them do a follow-up deposition related to the IME act.
So, I mean, they can ask them. Whatever the list of questions this guy asked, I have no objection to them asking them in the deposition.
Oh, yeah, so we're gonna start having the lawyers do the doctor's IME questioning.
Well,
You're losing this one.
I mean, you can at least you can get a feel for whether there is a need for that.
Well,
They haven't filed a motion.
Well, if
Go
I may
ahead.
speak, this is Laureen Frister for KeHe Distributors. You were here, Floyd, a month or 2 ago when these neuropsychological IMEs came up with regards to another plaintiff. And Mr. Kemp and Pepperman stated that all of their clients have emotional distress, and and we were given notice of those claims in the complaints. And also 2 days ago in an email, Mr. Pepperman stated that all of these plaintiffs have traumatic brain injuries. So we would like.
Wait, traumatic brain injuries or psychological problems?
His email said traumatic brain injury.
Will somebody hit them with one of the bottles? I mean, what is that?
I don't-
Eric?
I think she misunderstood my email. I was willing to work with them all, and they're demanding 2 days, 14, 15 hours of deposition when they have, general emotional distress damages from going through a traumatic event. I just made the point that I thought the request for a 2-day IME was unreasonable. And in my experience, I've never had one of these last more than 4 hours. And that was in a case involving a traumatic brain injury, which is, I could see maybe you need a longer one for a more serious traumatic brain injury where there's multiple, brain issues. This is just, straightforward emotional distress damages. And
Okay, Floyd, I
I
responded to these concerns and I said, please let me know what defense examiner did these, the interview and testing in 4 hours. I'd love to know and then discuss what they're doing with my expert to see why his is taking longer. And I also said we can do this in 1 day. It's spread out over 2 days to give the plaintiff, lunch, an hour and 15-minute lunch break, and then several 15-minute breaks during the day and get them out by around 4 o'clock. So it can all be packed in 1 day. And the quote from Eric's email says, I've never had one of these take longer than 4 hours, including with clients who've suffered traumatic brain injuries. So, I mean, that is concerning. That's putting us on notice that these, in addition to the statements made at the prior special master hearing, that we need these neuropsychological IMEs. I've been asking for dates for several weeks, and I even said, while we're working out issues with the parameters of the IME, let's just get them scheduled. I gave them dates beginning next week, and they're refusing to even select a date. So I think while we work these issues out with you, we can at least get something on calendar, maybe even get these IMEs done before their depositions. I mean, we're on.
But you kind of, but somebody has to justify a neuropsychological exam generally based upon the complaint, answers to interrogatories, medical records, or their testimony. So you don't have an objection to taking their depositions first, do you?
We can do that, but I'm concerned about plaintiffs' assertion at the prior special master hearing that all of their clients have emotional distress and were on notice of it because it was pleaded in the complaint. None of the plaintiffs in previous cases that I'm aware of really had any emotional and any evidence to support a claim of emotional distress, but my understanding was there were psychologists that performed IMEs, or at least ones were discussed during the special master hearing.
Well,
so if plaintiffs want to stipulate, look, we don't have these, TBI or emotional distress claims, and that'll be easier, and I'll drop
that's not my question. How did you pick these 5 people?
These are the 5 people that assert claims against my client. So I'm not concerned about plaintiffs that are not asserting claims against KeHe.
Well, why don't let's get their depositions, or somehow you need to show me. I'm not contesting it, but I don't have anything in front of me. Why don't you take their depositions and then submit your request for the IME? And if you, Mr. Pepperman, can't work it out, just submit it to me. But I need something other than they have emotional claims. Either their deposition testimony or one of their fact sheets, their medical fact sheets, something to justify the IME unless counsel stipulate to it.
Okay, that's fine. I think it was in the KeHe case where the KeHe plaintiffs did not, during their depositions, nothing was referenced regarding emotional distress. I think they outright denied it. And in that case...
that might happen here and save you some expert fees.
Okay, yeah,
I just need something, a medical record, a medical fact sheet, something, unless they stipulate to it. I need something generally to show, here's what they said the deposition, we want this explored. Something like that, or on the fact sheet.
Okay.
Why don't we take their depositions first and try to get that over with?
I'm happy to do that, but some of the depositions are scheduled for the beginning and middle of June. And we have the initial expert deadlines coming up in July. So I don't know, it's going to be very difficult to take their depositions, bring this issue before you and conduct the IMEs and have the experts prepare a report before the initial expert deadline.
When is the expert deadline?
July 15th.
Yeah, this is probably going to have to be extended. But I'll work with counsel on that. They're aware of the problem too. So the longer it takes for them to make their clients available, the more we'll have to make those adjustments.
Okay. The second issue that we're having with the IMEs is that the plaintiffs would like to record not only the interview portion of the IME, but the psychological testing, which is supposed to be confidential.
Well, it's not confidential to their own attorney if they agree to it. Yeah, I can see that's going to be an issue. We'll cross that bridge when we get to it.
Okay, and just really quickly, the third issue that I'd like to bring your attention is at the last hearing, you granted blood testing for Carla Moreno. We've tried to get updates, but we have not gotten a response on whether she has had the testing and when it's going to be.
I thought she went in. I just heard that.
My understanding was she was, I think on Monday, I was told she was planning to go in tomorrow, which would have been yesterday. So I thought that those test results were going to be automatically transmitted to your expert that's not the case. I think,
Can you follow up on that today or
Yeah,
tomorrow?
yeah, that's fine. We should.
All right, was there anything else? I can see I'm gonna have to start ordering the transcript. You keep telling me what I did in last year.
Yeah, so, KeHe, we've been trying to take.
Wait, am I done with her? Are we done with the IME issue?
Yes,
This is
thank
what we're-
you.
You know, I mean, issue in the first place. We've been trying to take KeHe depositions. We have names that we've given them. And so, you know, we teed this up and May 17th, our last email saying, give us the name, give us the dates for Sanderson, Beaton, and someone named Allison.
Is that with KEHE?
Yeah, right. And so instead of giving us names of these witnesses, 4 days later, they filed this IME thing. So I think this is maybe a little tit for tat, but regardless, I'm entitled to take the depositions of these 3 people. And I think they need to give us some dates.
They're specific, it's not 30v6.
No, we've got specific names, Richard Sanderson, Mark Beaton.
Well, that's in the email.
Right. And then there's also P and K, the Atchison, which I understand they're getting us. But what about these other 3? We've been trying to
What's the
take.
date of your email?
This is the follow-up email on May 17th. I think the first email was May 8th.
Who has KEHE?
May 8th.
Hi, this is Caitlin Zapf for KeHe. I wanted to raise this at the meeting because there is a correlated issue. I wanted to discuss document production by my client. And out of an abundance of caution due to some of the rulings in the prior cases, my client recently did a secondary search to look for additional communications between Real Water and KeHe. And although Real Water should have already produced all of these, so we don't anticipate there will be anything new to the litigation per se. There may be additional documents. And so at this point, we're unclear how many are duplicative in terms of from duplicative custodians or from sales reps that didn't have Real Water email addresses. So we've uploaded the documents and added attorneys to review the documents and produce them as soon as possible. But I wanted to involve the plaintiffs in this process to see how we could produce the documents faster. From my client's perspective, their primary concern is potentially commercially sensitive pricing information. And so
The court reporter list.
pricing.
Oh, price,
I missed it now.
commercially sensitive price.
Oh, pricing.
Right. So, you
Well,
know,
if
our
that's the
issue,
only- If that's the only issue, redact it, produce it, we can fight about that later.
absolutely, it's not that, it's that the documents have to be reviewed to determine which ones have the pricing information. So in trying to see if we could produce these faster, one option would be to essentially designate them all as attorney's eyes only initially so that we could produce them, and then we can, you know, de-designate them as such, so that plaintiffs have them earlier. Otherwise, you know, we can go through them individually to determine what information needs to be designated attorney's eyes only. But we're trying to come up with ways to make the process faster and be able to produce them right away.
What's the amount of documents?
You know, I'm not exactly clear because again, a lot of them might be duplicates that have already been produced. So my client cast, you know, a wider net to try to make sure there were no documents that were missed. And so it's unclear which of these have previously been produced.
Well, that's the least of our problems. If we end up with a duplicate.
They should have been produced.
Right.
I don't know. What are you talking about previously produced?
No, she's saying,
Real Water's production has been limited at best.
yeah, well, not only that, I'd rather you produce and worry about having an extra copy later. And also produce them and worry about redacting pricing information. That's not.
How can pricing information be an issue at this point then? Real Water's been out of business for over 4 years, so price that they're charging KeHe, what?
it's not that only, it's that pricing is the most sensitive piece of information in my client's business. So it's the matter of, other essentially co-defendants being able to determine how they do their price markup and how they determine their pricing formulas. So it's that they could piece together various pricing information and come up with sensitive information. So again, I don't think the plaintiffs are concerned with this pricing information, but it's a concern to my client. So we're trying to offer solutions so that we could produce the documents immediately if we could designate them attorney's eyes only.
Why don't you call?
So I'm just trying
call Mr.
to come up with
Pepperman.
solutions.
Yeah, call Eric after the hearing. And
But I don't know what this has to do with.
but I want this worked out. I mean, if you have to redact the pricing, you could do that and then they'll fight that out later, but we need these documents produced within the next few days.
Not only that, we have the quality assurance people.
But-
that have nothing to do with pricing. So why could we be given dates in the last month for Sanderson being written?
Well, I think these documents contain everything, probably including quality assurance.
Well, they were supposed to have produced their quality assurance.
No, these documents are communications with Real Water.
Okay, well, so.
Well, then they can't be privileged. It's communication.
I'm not claiming they're privileged.
You're saying
I'm saying there's commercially sensitive information that is.
And you don't have any idea digitally or page wise what we're talking about?
Based on what I've seen, again, I don't know how many of these have already been produced, but it could be 30,000.
Emails?
Well, there's lots of attachments, so each of those are counted differently.
Sure.
I have a real
And
tough reading. There's 30,000 documents between KeHe and Real Water.
But hold on, this is a problem that we've been dealing with for a long time now, Floyd. Of course, Eric and Will want me. But this is kind of what we're dealing with Real Water. And so,
And terrible hurt.
and of course, terrible Herbst. But the fear of being, producing something that duplicates something we've already received,
That's the least amount.
that's the least of all of our worries. Because we found out from terrible Herbst that they produce things that we had not seen from Real Water and that Real Water could not find in their own searches. So what I'd like for you to discuss as a part of what we're dealing with KeHe here is, and Joel and I have discussed having a conversation after this meeting, but I need to have, or we would like to have as soon as possible, next week, whenever you can get us in front of you, we need to have some finality to Real Water's production, the Terrible's production, and now 30,000 potential pages of KeHe. Now, Joel and I will talk today, and then hopefully by tomorrow, we'll have something in front of you in the form of an agenda. But the judge denied our motion last week because without prejudice on Real Water's production. I need to get that back in front of the judge. So I definitely need to have that. If you could schedule us for Tuesday or Wednesday of next week in the morning, I would appreciate it, because I anticipate that I'll have a conversation with Ms. Davis on terribles. Mr. Pepperman will have a conversation with Caitlin. I don't know how to pronounce her last name. It's only part of it
Zapf.
showing on Zapf. And I will also have a conversation with Joel, hopefully today. But if you could schedule something on Tuesday or Wednesday of next week.
Well, I don't know what, I can't, I'll check.
We have board stuff. We have
So if you could do that, because I'd like to tee this up, because there's a chance I can get this back.
That's it, I'm guessing I'm booked, but I'll squeeze something in somewhere.
Thank you. I appreciate it.
Let's not worry about the duplicates for KeHe.
Floyd.
Let's get out what you can, even if you redact something. Is that Joel?
I think that's
Yeah.
Joel.
Floyd,
Right, but
we're picking a
it's a
jury
matter
on
of this.
Tuesday.
Okay.
So I can't be at a hearing and be at picking a jury at the same time.
Well, we don't start till 1.
We don't start till 1,
You
Joe.
can multi.
We don't start until 1.
Same problem, no notice,
We're giving you notice. This is 4 days notice now.
4 days
I'm not
notice.
sure I can do it. I'm not sure I can do it Tuesday. I'll squeeze it in Tuesday morning if I can, or at the earliest time.
Thank you.
Can we get back to where we started? See, the Sanderson, Beaton, and Hudson, quality assurance people. So we've been wanting to take their depositions because we have to give them to Dr. Quality Assurance. So she can base her opinions on her testimony. And that's why we've been chasing.
Here's the only problem. Suppose this new document production, if you want to take it a second time, it's going to be
There's no document between real water that's relevant to.
right. Who are the quality assurance? These are
Richard
KeHe.
Sanderson. And I just want a date. Richard Sanderson, Mark Beaton. And
What's the last name?
Beaton. Sanderson, Beaton, Beaton, and Hudson, Autsen. We've been trying to take them before the trial started, but
How soon can you give dates for those?
Well, our issue was that we were concerned that plaintiffs are going to argue they were prejudiced if they took the depositions before they received a document production. So that's why we wanted to raise it and see if the plaintiffs wanted the documents first or wanted to take the depositions first, and then, we wouldn't object if they want to redepose these people if something comes up in the emails, but I'm trying to prevent the fact of them saying that they're prejudiced because the depositions were already taken and now they have new documents. And so I'm trying to prevent that situation and make sure they're aware of the fact of these documents so that they can participate in the decision of the order of this.
Well, we have a court reporter, and if my memory isn't good enough, her transcript will indicate to you that Mr. Kemp asked to take the depots first. Are these people local? Where are they?
No,
Where are they?
they're all out of state.
Do you know where?
Yeah, Richard is
Last name.
in the
We are on a first name basis.
Anderson. Yeah, Sanderson is in the greater Chicago area, but he does travel quite a bit nationwide. So I can't tell you on any given week where he'll be.
Well, he's going to be here on Monday.
actually I've been doing them on video.
Okay,
Well, if it's not a PMK deposition, I don't think that he's required to come to Nevada.
He's going to do it by Zoom.
Fine Zoom.
What about Beaton?
Great. Beaton is located in California.
And Austin?
Again, Outson, the greater Chicago area.
All right, we'll work with Mr. Kemp, but we've got to get some dates. Could you get a hold of them today and get back to Mr. Kemp on those dates?
I mean, two of them are in Chicago, so I'm not sure that'll happen. But
Yeah, it's too late. It's still now, but get a hold of them in the morning and then get back with Mr. Kemp. And he's doing them by Zoom anyway.
okay, I will get back with some dates.
Yeah, I normally don't have to get involved in depot scheduling, but I'd be glad to help the two of you if I need to.
Thank you.
Okay. I've got two proposals. Did I cover the KeHe
I think we did.
issues? And what about, and we went over the KeHe document production.
So about the document production, I understand that you had advised us to redact the pricing and produce the documents,
Stop.
that's
There's
gonna.
misunderstanding. Yes, sir. If that's the only issue, do it. If that's an easy issue, do it. I'll fight, if there's a dispute on that later, it'll be easy for us to get back on a Zoom and take care of it. It's just, I want to make it as easy as possible for you to produce the documents. So if there's
Right, and that's
proprietary stuff you want to try to redact, go ahead. When they see the documents with it redacted, if they think they've seen what they need to see, then there won't be a dispute. But that way it might be easier for you to produce it.
that's fine. That just means that they have to be reviewed page by page, so it's going to take longer.
Well, I try to
because we
think.
have.
Oh, so if I allow you to
We have to
redact
look at
it,
each
that's
page
gonna,
to determine.
wait, that's backward. So if I allow you just to redact it so we can get them out sooner, you're saying, oh, no, that'll take longer.
No, what I'm saying is if they're marked attorney's eyes only, then we can get them out.
Why don't we
But
try
if we have to,
Let's
if we
do
have to
that.
review them page by page,
No, give it.
then it's gonna take longer.
Give it attorney eyes only.
And I shouldn't be mean attorneys and paralegals.
I do. I'm just trying to eliminate attorneys sharing it with the parties, other parties.
Okay,
Their
work
clients.
that out with Pepperman or Kemp and the language of it, and then get them out.
Okay,
And if you two have any problems at all, I don't need everybody to resolve it. If the two of you have a problem, we'll just get the three of us on a Zoom or on a phone call and take care of it.
will do. Thank you.
Did I cover everything KeHe wanted to cover?
Yes.
Yeah, I thought so. What's left?
We did discover them, right?
Well, the judge did some. I've got different proposals on that. I don't know.
Oh, no, that was, I think there's two different cases. Brown, yes, we have all the discovery deadlines set in order. February trials with Bonner,
But yeah, it's more than that.
Bonner, Chang,
And Buren,
and Van Buren consolidated case. I
What's the
think
middle name?
Chang,
Well, Chang is in that group. So it's Bonner, Chang, and Van Buren.
and Ford,
Ordinance,
Ford,
EOR, and a
What deadlines do we need?
You know, this one's tricky because of the February trial date. I don't think we'll have a problem agreeing to the deadlines. We've worked well on that before. It's just, I think trying to avoid some Christmas deadlines and things like that. There's just some issues we got to talk through and picking which, unlike not great scenario we want to go with. So I would suggest that we
Try to route and approve the
yeah,
agenda. And
we'll try to stipulate on
if
the
you need
date.
to redline the dispute, let me know. I have to tell you though, all of you lawyers, the last thing you want me to do is set your calendars. So I urge the lawyers to try to work together to work that out.
We will. I think just tabling that, if we can't reach a stipulation, we'll submit it.
That's February next year trial.
seventh is. Maybe it's 2. It's February.
Okay, I think we've covered KeHe and these plaintiffs. The rest of you folks on our Zoom, do any of you need to cover anything? Okay. All right, I think that's it.